Okay, we're going to talk about all traffic is national in the USA today. So this is Title 49, United States Code, which is the Transportation Code, federal, and the Subtitle 6, Motor Vehicle and Driver Programs, and let's notice there's Part A, B, and C, and so notice the numbering, so Part A is 301, and Part B is 311, and Part C is 321. So Part A, general, what we're going to be talking about is the National Driver Register, which is, and the National Motor Vehicle Title Information, and where they're applicable to, Chapter 303 and 305. Now, so the National Driver Register, the definitions, is, and that's where we really go, because that's, once we go there, we know it doesn't apply to us. A motor vehicle is drawn by mechanical power and used in the public streets or highways. A motor vehicle operator's license is a license issued by the state, and a state means the state of the United States and the territories. Now, and I intend to show that this is what this means, is that they're saying it's the state of the United States, and then it lists all the states, because the territories are actually states. And so this is the National Motor Vehicle Title Information System, and this Chapter 305. And we'll go to the definitions again. Certificate of title, a document issued by state showing ownership. Insurance, okay, well, we know about that. Operator means an individual or entity designated as the operator. And state means a state of the United States or the District of Columbia. And then this is kind of interesting. This is 31141, Section 31141, which is basically, this is commercial. This is under Part B, commercial. And it says that if the state wants to make regulations for commercial motor vehicles, they have to get permission from the federal government. Isn't that interesting? And this is Part C, Information Standards and Requirements, and we'll go into the definitions again. Insure means a person in business of insuring any part of a motor vehicle, title, vehicle insurance policy. Motor vehicle, a vehicle drawn by mechanical power and used on the highways. Passenger motor vehicle defines as not designed not to carry more than 12 individuals. And state, okay, is the typical answer, the state of the United States, and it lists territories. Now, this is all taken from Legal Information Institute, which is Cornell University. And if you look here about the middle, there's 3 tabs, U.S. Code, Notes, and Authorities, okay? Well, all of that stuff that we just looked at was taken from that U.S. Code tab, okay? I just pasted it in there. And so Notes is where all of the stuff comes from. So if you ever want to do research, I mean, that's how you find out where the stuff comes from. So this actually comes from, and this actually goes quite lengthy. There's probably 2 or 3 pages of text. But the source of this is Public Law 103-272, located at 108 Stat 973, and Public Law 97-364, located at 96 Stat 1740. So what we're going to do is we're going to go to this 97 Stat, Public Law 97-364 at 96 Stat 1740, and that's right here. And notice here it's 96 Stat 1738. Okay, so, but the reason it's at 1738 is the page of the book. And the reason we're there is because I want to see what the preamble of the act says, because that is what determines what that act is going to be about. And this is the preamble. And notice here it says an act to amend Title 23 of the United States Code. And now if you go back here, this is all 49 United States Code. See, 49 United States Code. Okay, so anyways, so in 1982, it was originally an act to amend Title 23 of the United States Code to encourage the establishment by states of an alcohol training traffic safety programs. Okay, get drunk drivers off the roads. They always use these little hot button issues, and then once they have it, they go and use it all sorts of ways that it wasn't intended. And it's the typical thing they like to do. So anyways, this is Public Law 97-364, located, the preamble is at 96 Stat 1738. I'm not going to go, well, actually I am. This is actually taken from the definition section of Title 23. And if you go to, in this title, the following definitions apply. And then definition number 25, the term state means any of the 50 states. Okay, so the point I want to make, as you noticed all those definitions into Title 49 United States Code, the point I want to make is that if they want to say that a state is any of the 50 states, they have the ability of doing it. Okay, and right here is a good example of when they do it. Okay, and so, and this statute right here, Title 49, was originally Title 23, which is highways, and that was the definition of state there, and they moved it there for a purpose, and now the definition is different. Okay, think about it, boys and girls, and so that's for a purpose, and they changed the definition because they didn't want it to be any of the 50 states, obviously. So now we're going to go and look at Public Law 103-272 and the 108 Stat 973. And that is, first of all, we'll talk about the justum generis. Okay, a justum generis is the same kind, class, or nature in the construction of laws, wills, or other instruments. A justum generis rule is that when a general word following a enumeration of persons or things by words of particular or specific meaning, such general words are not to be construed in their widest sense, but are to be held as applying only to persons or things of the same general kind or class as those specifically mentioned. This is taken from Black's Law Dictionary, 4th edition, and an example is if a law refers to automobiles, trucks, tractors, motorcycles, or other motor-powered vehicles, vehicles would not include airplanes since the list was land-based transportation. This is taken from Black's Law Dictionary, 8th edition, a canon of construction. Okay, so it's the maximum law, boys and girls, that when a general word or phrase follows a list of specifics, the general word or phrase will be interpreted including only items of the same type as those lists. For example, the phrase horses, cattle, sheep, pigs, goats, or any other farm animal, the general language or any other farm animal, despite its sitting bred, would probably be held to include only four-legged hoofed animals typically found on farms. Thus would exclude chickens. So, anyways, now this is public law. Now let's go back here. The second one was Public Law 103-272, located at 108 Stat 973. So there's Public Law 103-272, and it's the preamble. Now it's 108 Stat 745 instead of 973. And this is, if you read the preamble here, to revise, codify, and enact without substantive change, Title 49, United States Code. Now, this is very similar to when they enact a title as positive law. If you go through this thing, it's like about 500 pages, and at the end, it's got about 20 pages of repealed statutes. And so this is very similar. I'm still trying to get my head around it because usually it says to enact as positive law, and it doesn't say that here. But anyways, so the point is that I think that's what it is, but it may not be. But at any rate, it is an actual act of Congress, and it's Title 49 United States Code. And so what they did is and if you go through the repealed section, it talks about repealing that act for Title 23 United States Code, and they put it into Title 49. So they obviously wanted to change the definition section. I'm not going to go to 947 or whatever the page is, because all of that stuff was basically the stuff that we just talked about from the Legal Information Institute that was in the first few slides of this presentation. So the point is that they moved it to Title 49 United States Code for a reason. And they wanted to, among other things, they wanted to change that definition. And they knew exactly what they're doing. Okay, now this is a continuation of that sheet that talks about the notes, remember? And so there's a couple more statutes here that they're talking about, and there's Public Law 110-177 located at 121 Stat 2543, and there's also Public Law 109. Let's get in there closer. Public Law 110-177, located at 121 Stat 2543, and and Public Law 109-13 located at 119 Stat 311. Now, just for information, this is 121 Stat 2543 is the Statutes at Large, Book 121, which is a certain year. This is probably 2008, and it's page 2543. And 119 Stat is Book 119. It's probably the Statutes at Large for the year 2005, and it's at page 311. Anyways, so let's go there. This is Public Law 110-177. So that's the first one. And it's located at 120 Stat 2534, okay? And so they're saying that this is at 2543. The preamble of the act is what it is an act to amend the United States Code to protect judges, prosecutors, witnesses, and for other purposes. And so now we'll go to 2543, and it's what they're talking about as minimum requirements for the Real ID Act of 2005. Okay, so and what they're essentially saying is that if you go to subparagraph 2, it says individuals addressed referred to in paragraph 1. In case of a justice of the United States, the address of the Supreme Court, in other words, under the Real ID Act of 2005, on the driver's license or whatever identification card of the justice of the Supreme Court, they put down the address of the United States Supreme Court. And the judge of the federal court is the address of the courthouse. Okay, they don't put down their real address. And I think that's probably a good idea, given that there's some wackos out there, and judges definitely tend to make enemies. Anyways, that's what this is right here. It's a closer shot. And so now this is Public Law 109-13. Remember, this is Public Law 109-13 at 119 Stat 311. So this is Public Law 119-13. Now this is so typical of what happens. You see this quite a bit, quite frankly. But this is an appropriations bill, okay? The Real ID Act is attached to an appropriations bill, and this is just so much garbage. This is just a complete fraud. The Real ID Act was a temporary act. The appropriations bill only lasts for a year, and then they come up with another appropriations bill, and so this is all the kind of garbage they pull sometimes, and so that's the point. This is why you go and look at the preamble, because you want to see what this act is about, okay? This is the kind of games these guys play. Anyways, Public Law 109-13 was is an appropriations bill, and the Real ID Act was attached to the appropriations bill. Now, this is actually, if you look at the very bottom, Title II, improved security for driver's licenses and personal identification card. Okay, so that's the so-called Real ID Act. That's at 119 Stat 311. Okay, and that's the site that they're talking about there. This is the so-called Real ID Act, and here's 119.312. Okay, which is where text is, or a lot of it is, and it says here. Driver's license means a motor vehicle operator's license is defined in the Taxation Code, and it says the state means the state of the United States, and then it lists them. Okay, so that's all the territories, and that's all very important because it's the same definitions that are in the Transportation Code, and we're going to go into what that's all about right now, or in a minute. Legislation may not be added to an appropriations bill. The so-called Real ID Act is part of an appropriations bill, which makes it void. This is taken from an act to provide for a government for the District of Columbia, located at 16 Stat 419. That's Book 16 Stat, page 419, which was approved in 1871. And at Section 12, it says, "And be it further enacted that every bill should be read at large on 3 different days in each house. No act shall embrace more than one subject, and that shall be expressed in its title." Well, I don't remember seeing in that title of that act anything about Real ID. Do you remember seeing anything in there? Let's go back and look at that. Let's see here. This talks about appropriations for defense, the global war on terror, tsunami relief, and fiscal year ending September 30th, 2005. Okay, I don't see anything about Real ID in there. Sorry, I'm just not getting that this is an appropriation bill. Anyways, no act shall embrace more than one subject. It shall be embraced in the site. Let's go back here again. I want to see what the short title, the title. Okay, so now that's the preamble. This is the title. The act may be cited as emergency supplemental appropriations for defense, global tsunami, global war and terror, and tsunami relief. Okay, still, I'm not seeing anything for real ID. And if any subject shall be embraced in an act which shall not be expressed in the title, such act shall be void. Only so much thereof as shall not be expressed in the title. Okay, so which is one point. Okay, the second point is legislation may not be added to an appropriations bill, and this is a Supreme Court case, Andrus versus Sierra Club at 442 U.S. 347. Says the traditional distinction which Congress has drawn between legislation and appropriation, the rules of both houses prohibiting legislation from being added to an appropriations bill. And that's exactly what they did, is they added legislation to an appropriations bill. So anyways, furthermore, and there's court cases that talk about it. I didn't put it up here, but there's court cases that say that appropriations bills are temporary. They only last for a year, and so therefore the Real ID Act expired a long time ago. This is under Title 18, United States Code, Section 31, which is really the proper definition of motor vehicle. Motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes. And it even goes on to define the term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. So if you're traveling on the public highway from point A to point B, you do not have a motor vehicle, boys and girls. So what's the difference between federal and national? And that's, that's important because remember, it talks about this, the national driver's license register and the national motor vehicle registration. Okay, so what's the difference between federal and national? Okay, so, and this is important. Federal is of or relating to a system of associated governments with a vertical division of governments in national and regional components having responsibilities relating to national government of the United States. That's Black's Law Dictionary 8th edition. This is Black's Law Dictionary 4th edition. Belonging to the federal government of the Union of States, founded on or organized under the Constitution or laws of the United States. And then if you go about halfway down, federal is somewhat more appropriate if the government is considered a union of the states. National is preferable if the view is adopted that state governments and the union are two distinct systems, each established by the people directly, one for local, the other for national purposes. And that's Black's Law Dictionary, 4th edition. National is pertaining or relating to a nation as a whole, commonly applied to American law, to institutions, laws, affairs of the United States, parts of government, as opposed to the several states. The term national, as used in the phrase national of the United States, is broader than the term citizen, and that's true. This is taken from Black's Law Dictionary, 4th edition. There's the U.S. passport application even talks about a non-citizen national. Nation is a people aggregation of men existing in the form of organized drill society, usually inhabiting a distinct portion of the earth, speaking the same language, using the same customs, possessing historic continuity and distinguishing from other like groups by their racial origin and characteristics, generally but not necessarily living under the same government or sovereignty. And that's Black's Law Dictionary, 4th edition again. So this is Supreme Court case Downs versus Bidwell, located at 182 U.S. 244 at 1901. Okay, and this is so a bunch of things changed right around this time, the case. And so we're going to have several cites for this case in this presentation. This is eliminating then from the opinions of this court all expressions unnecessary for the disposition of the particular case, gleaning therefrom the exact point decided in each. The following propositions may be considered to be established. Number one, that the District of Columbia and the territories are not states within the judicial clause of the Constitution, giving jurisdiction in cases between citizens of different states. Isn't that interesting? Okay, so therefore the DC and the territories are not in Article 3. okay, of the Constitution. So if you're in DC and the territories, you do not get an Article 3 court, okay? The territories are not states within the meaning of as revised statute 709, permitting error from this court in cases where validity of a state statute is drawn in question. Okay, so you cannot do a writ of error from DC or the territories. The DC and the territories are states as that word is used in treaties with foreign powers with respect to the ownership, disposition, and inheritance of property. Okay, well, that's very interesting. So now we're talking about that the DC and the territories are states. Okay, so now you can see how in Title 49, United States Code, they list the states of the United States, and they list them, they call it as a state of the United States, and they list all the names. Okay, those are all, that's a justum generis, and those are all the states. I mean, and there could be more. Anyways, notice it doesn't use the word includes. We're going to talk about that in a minute. That the territories are not within the clause of the Constitution providing for the creation of a Supreme Court and such inferior courts as Congress may see fit to establish. Well, that's a foregone conclusion. It's basically restating paragraph 1. They're not in the judicial clause of the Constitution. And so then it goes on, and then paragraph 6, that where the Constitution has once been formally extended by Congress to territories, neither Congress nor the territorial legislature can enact laws inconsistent therewith. And so once they grant statehood, then they can never take it back, and they can never pass laws that are inconsistent with the Constitution. And so all of this is very interesting. And notice here, this with respect to ownership, disposition, and inheritance of property, they're bringing in the Sesticate Trust. That's in paragraph 3. And it's interesting, the DC Code was passed in 1901, and it talks about that this is the same case. We are therefore of the opinion that the island of Puerto Rico is a territory appurtenant and belonging to the United States, but not a part of the United States within the revenue clauses of the that, boys and girls, what they're saying essentially, you got to think of the Constitution as something that limits the government. Okay, and so if they're not within the revenue clauses of the Constitution, they can do anything they want in territory. Okay, and so think about it. So they go and they can do any kind of taxes they want. There's no limits at all, and that's what they're essentially saying here. Soon after this case, they passed the DC Code, which talks about Sesticate Trust and arbitrary plenary jurisdiction, and they started calling the government the administration, okay, like the Obama administration, the Clinton administration, the Reagan administration, okay. This is a document called Jurisdiction Over Federal Areas Within the States, Report of the Interdepartmental Committee for the Study of Jurisdiction Over Federal Areas Within the States, Part 2, a text of the Law of Legislative Jurisdiction submitted to the Attorney General and transmitted to the President June 1957. And this is located on page 158 of that document. It's about a 400-page document. Anyways, and that's only Part 2. Then there's Part 1. Anyways, international law rule, okay, and adopted for areas under federal legislative jurisdiction, okay, and it goes on and it says this is a subparagraph of that section, okay, federal, state, civil law, including common law. It federalizes state civil law, including common law. The rule serves to federalize not only the statutory, but the common law of the state. And there's court citations about how they can do that. And and then it goes on page 165. It says federal and state venue discussed. The civil law is effective in an area of exclusive federal jurisdiction or federal law, notwithstanding their derivation from state laws. Okay, and a cause arising under such laws may be brought in or removed to a federal district court under sections 24 or 28 of the former Judicial Code, now sections 1331 and 1441 of Title 28. And so, point being is that Many state statutes are actually federal statutes. And this is Robinson versus Norado. In the sense of public international law, the several states of the Union are neither foreign to the United States nor are they foreign to each other, but such is not the case in the field of private international law. Okay, and so now we're talking, see, there's two entities, okay? And so the corporations are not foreign to the United States, okay? It's really a subcorporation, whereas the de jure entity is, okay? And that's what they're talking about. The two jurisdictions, in the sense of public international law, several states of the Union are neither foreign to the United States nor are they foreign to each other, but such is not the case in private international law, and they're talking about the de jure entities here. The United States government is a foreign corporation with respect to a state of the Union, and that's Henry Merriam's estate. That's the Supreme Court. And this is another cite from Downs versus Bidwell. The Constitution has undoubtedly conferred on Congress the right to create such a municipal corporation organizations as it may deem best for all the territories of the United States. So all municipal corporations are in U.S. territories, okay? And so there's two separate jurisdictions in every state, and if you're in the corporation, you're in a territory. It's military dictatorship. You do not get an Article III court. It's plenary. I mean, all sorts of things. There's been created a fictional federal state of XXX within a state, which this is Schwartz versus O'Hara Township School District, quoting Supreme Court case, Howard versus Sinking Fund of Louisville. And so there's a fictional federal state of XXX within a state. This is actually taken from a document that was recorded. The Judiciary Courts in the state of Texas is a subsidiary of the state of Texas, as found in the affidavit of Daniel Lee Swank, which is recorded with the Liberty County Recorder, which is attached to the Dun & Bradstreet listing for the Judiciary Courts of the state of Texas. Here started 1845, headquarter location, Supreme Court Building, Austin, Texas. Top executive, Thomas R. Phillips. Chief Justice, business type, corporation, for profit. On page 2, it shows as notice this company is a subsidiary of Texas state court system, which includes Supreme Court, Court of Criminal Appeals, Court of Last Resort, 14 courts of appeals with 80 judges, District Court with 386 judges, Criminal District Court with 10 judges, County level court with 445 judges. Now, this is the actual affidavit that's recorded, and if you look at the top, there's a barcode with the recording number, and it's the affidavit says that I, Daniel Lee Swank, affiant herein, state under public law 97-280 that I am competent, I have personal knowledge of the facts herein, and state the facts herein are true, correct, not misleading. I have retrieved the attached 2 pages of the Dun & Bradstreet Business Background Report regarding the for-profit corporate status of the Judiciary Courts of the state of Texas from Dun & Bradstreet's internet website, and it's Exhibit A. And so, let's go there. Okay, this is Exhibit A, and let's get in closer. It talks about the Judiciary Courts of the state of Texas, a subsidiary of Texas, state of Austin, started 1845. The Supreme Court building is the headquarters at Austin. Chief Justice Thomas R. Phillips. Line of business is the state court system, and down at the bottom, it's a for-profit corporation. And then this is the second page of this, and it goes here. It talks about operations, and that's as of December 2nd, 2004. As noted, this company is a subsidiary of Texas State of Inc. State court system, which includes the Supreme Court, Court of Criminal Appeals, Court of 14 courts of appeals, 80 judges, district courts, 386 judges, criminal district court, 10 judges, county level court with 445 judges. The department contains 14 courts of appeals, 375 district level courts, and 420 county level courts. Okay, so is there any surprise? This is a corporation. This is a subsidiary of United States, DC. Okay, so you're in the territory if you're dealing with these people, and it's full of U.S. citizens. I mean, just it goes on and on. Okay, and there's at the bottom of this page is the official records of the it's a recording. It was the recording number and the B, and then it's a certified copy because there's a little affidavit there on the right hand side that talks about the court certifies that it's a true copy. So in this state, now we'll look at some Texas statutes, okay? And every state, well, they have something in them, I guarantee you. Some states, like in Washington, I've seen a statute almost identical to this in Washington state. And so every state's going to have variations of this kind of thing. But so in Texas, in this state, this is Texas Tax Code, section 151.004. In this state, it's the title of that section. In this state means within the exterior limits of Texas and includes all territory within these limits ceded to or owned by the United States. Okay, now, includes is limiting. This is Supreme Court, Montello Salt versus Utah. Include of the participial form thereof is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, and mix involved. And then there's a couple law dictionary or dictionary definitions. American Dictionary of English Language. Include, to confine within, to hold, to contain, as a shell includes a kernel. A pearl is included in a shell. To comprise, to comprehend, to contain. And then Black's Law Dictionary, 6th edition, include, to shut in, to keep within, to confine within, to hold as an enclosure, take in, attain, shut up, contain, enclose, comprise. Okay, so the point is that includes is limiting. And so what they're saying in this statute is that in this state means within the exterior and includes and only is all territory within these limits ceded to or owned by the United States. Okay, and now this is the Texas Transportation Code, where it's section 501.022, motor vehicle title required. The owner of a motor vehicle registered in this state. A person may not operate a motor vehicle registered in this state. The owner of a motor vehicle that's required to be titled and registered in this state must obtain a title. Okay, it just gets better and better. Texas Transportation Code 521. See, the Texas Transportation Code is really a division of the U.S. Transportation Code. How about it, boys and girls? 521.021. A person other than a person expressly exempted under this chapter may not operate a motor vehicle on a highway in this state unless you get a driver's license. Texas Transportation Code, financial responsibility. A person may not operate a motor vehicle in this state unless financial responsibility is established. Texas Transportation Code 548.051, subject to inspection. A motor vehicle, trailer, semi-trailer, float trailer, mobile home registered in this state must have the following items inspected. Texas Government Code, okay? Why do you think the government's any different? Of course they're not. Again, all of these statutes are actually federal, okay? A municipal court of record is provided over by one or more judges. The governing body shall be ordinance appointed by municipal judges. A municipal judge must be a resident, a citizen of the United States, a bar member, have 2 or more years of experience of practice of law in this state. Texas Government Code 41.103, prosecuting attorneys and assistant prosecuting attorney must be licensed to practice law in this state. Texas Government Code qualifications. To qualify for appointment as associate judge into this chapter, a person must be a resident of this state and have been licensed to practice law in this state. Texas Government Code board duties. Board of Law Examiners, all bar members. All of the Satanist bar members, they're all DC citizens. Their job is to get you into the territory. To get you into the territory, that's exactly what they do. They want to assault you and get you into that territory so then they can really get away with it. The Board of Law Examiners, acting under instructions from the Supreme Court, as provided with this chapter, shall determine the eligibility for candidates for examination for a license to practice law in this state. The Office of Court Administration of the Texas Judicial System shall develop and maintain a model for the uniform written jury summons in this state. Juries are federal territory. Texas tax code, okay, well, we already know that's in this state. This state has jurisdiction to tax real property if located in this state. The state has jurisdiction to tax tangible personal property if the property is located in this state. Temporarily, if the located in this state for longer than a temporary period, temporarily located outside this state if the owner resides in this state. Okay, again, it's all talking about in this state. This is the Texas Tax Code. Law enforcement agencies, each law enforcement agency in this state. Okay, so that's Texas in talking about racial profiling. Okay, we're going to talk about that in a little bit. Okay, so they don't want to be doing racial profiling. They want to stop that. That's for sure. This is Code of Criminal Procedure. A warrant of arrest shall be authorized to execute the same in any county in this state. A search warrant is a written order issued by a magistrate. No search warrant shall issue for any purpose in this state. So it's all, that's the Texas Code of Criminal Procedure. Now we'll talk about, since we're talking about the government a little bit, we'll talk about Title 4 United States Code and Chapter 4, which is states. And if we look here, how about Section 105 that says state taxation affecting federal areas, sales and use tax, okay? Well, again, sales and use tax is a federal tax. Think about it, boys and girls. Excuse me. Income tax, Section 106. How about 111? Taxation affecting federal employees, income tax. This is all talking about the territories. This is all for the territories. State statutes are federal. All hospitals and health care, which is actually death care, all financial institutions, banks, real estate, insurance, etc., all labor organizations, all law enforcement agencies, the LEOs, the state order takers, all government agencies, courts, cities, counties, municipal corporations, etc., all taxes are federal. Now, when I talk about law enforcement agencies, I'm obviously not talking about peace officers, okay? Because peace officers are common law, and but if they want to be a law enforcement, a LEO, then they're not a peace officer, they're a LEO. And you ought to watch my video on LEOs, on law enforcement officers. Federal welfare. The officers of their court are U.S. citizens, or it's federal warfare, actually. Actually, it should be national warfare. All officers of their court are U.S. citizens. They're demanding Federal Reserve notes. All of their LEOs are U.S. citizens. Matter of fact, there's I remember recently, well, it's been 3 or 4 years ago now, there was a guy in Florida that started learning about this, and he went and announced that he wasn't one of their low-life scumbag U.S. citizens. He was one of their peace officers, and they fired his butt so fast your head would spin. And so, you know, in a case like that, it would have been better for all of you people out there that work in as peace officers. I mean, you have to do a lot of good and help people by understanding your oath and lawfully, you know, again, there's no duty to obey an unconstitutional law, and so you can still have your job and enforce the law or and be a peace officer is what I'm saying. And there's a difference between a peace officer and a LEO, and so I want all peace officers out there to know that I appreciate the work they do. So the federal national warfare, they're demanding Federal Reserve notes as used. This is taken from the Gold Reserve Act of 1934, Section 15, and using this act, the term United States means the government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. Okay, so Federal Reserve notes are meant for internal use of the government only. Under the international law of warfare, all parties to a cause must appear by nom juror, which is a fictitious war name, because an alien enemy cannot maintain by action during a war in his own name. And under Black's Law Dictionary, 5th edition, says a mixed war is one which is made on one side by public authority and on the other by a mere private person. Okay, so what do you think is going on when you're in court? Okay, that's commercial warfare is what that is. Capitis diminutio, this is the fictitious war name, meaning the diminishing of status through the use of capitalization in Roman law. Okay, this is all Roman civil law is what it is, okay? It's a diminishing or abridgment of personality, a loss, impalement of a man's status, or aggregate of legal attributes and qualifications. Capitis diminutio maxima is when they spell your name in all block capital letters. It's the highest and most comprehensive loss of status. This occurred when a man's condition changed one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and all family rights. And that's Black's Law Dictionary, 4th edition. Did you know that in the Old Testament it says that if you sell someone into slavery, that they're supposed to put you to death? Yeah, that's right. Yeah, make merchandise of you and sell you into slavery. It's death penalty. It shall be put to death. This is taken from Title 50, United States Code, Appendix 5, Trading with the Enemy Act. The President, if he shall find it compatible with the safety of the United States and the successful prosecution of the war, may, in paragraph B, regulate, direct, compel, mollify, void, prevent, or prohibit, or exercise any right, power, or privilege with respect to any property by any person subject to the jurisdiction of the United States. In other words, he's a dictator. Okay? He's basically a dictator, and he can do anything he wants. And that's the Trading with the Enemy Act. And all persons, okay? So we're talking about U.S. citizens. There is what they're talking about. They're making war on U.S. citizens. U.S. citizens are enemies of the state. And this is actually an act to terminate certain authorities. This is the National Emergency Act from September 14, 1976. And the point I want to make here is that Section 502 says the provisions of this act shall not apply to the following provisions of the law, the powers of authorities conferred thereby, and actions taken thereunder. And they're talking about the Trading with the Enemy Act, boys and girls. Okay, so they repealed everything else but the Trading with the Enemy Act. This is a book called The Non-Ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court, and it's associated with a case called Dyett versus Turner. Anyways, we can't, and I'm going to have several quotes out of that here today. We can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It's been replaced by statutes. They would be more truthful if they said there isn't any common law. It's been replaced by martial law. And that's exactly what's going on, is they've imposed martial law, and it's been here for decades. Watch my We're Under Martial Law video. In the meantime, civil law, which is the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule, equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And so that's exactly what they've done, is they've gone and, you can go in there and some judges will let you argue common law and let you get away with it. But I've seen it where you would go in there and you'd start arguing Constitution, and the judge would just look at the Constitution doesn't apply. And under their system, he's 100%. Okay, you're in federal territorial jurisdiction. It's dictatorship. They can do anything they want. U.S. versus Bevins, the exclusive jurisdiction which the United States have in ports, dockyards, ceded to them is derived from the express assent of the states by whom the cession was made. It can be derived in no other manner, because without it, the authority of the state would be supreme and exclusive therein. Okay, it's all voluntary. You've got to understand that. It's all voluntary. The well-established principle of law that all federal regulation applies only within the territorial jurisdiction of the United States. There is a canon of legislative construction that teaches Congress that unless a contrary intent appears in the legislation, is meant to apply only within the territorial jurisdiction of the United States, which is D.C. and the territories. And this is again Diet versus Turner. If a citizen acquires the same legal status or artificial character as those protected by the amendment through the operation of some statutory law of Congress, then said citizen may be brought within the venue of the amendment as a statutory juristic person. By this means, citizens' birthrights become of no effect, and their rights are reduced to the inferior character of statutory civil rights, mere legislative privileges. So there's two classes of citizens. There's state citizens and there's federal citizens. You can be a state citizen without being a U.S. citizen. Watch the Do You Know Who You Are video. A U.S. citizen is not entitled to an Article III court, but instead gets an Article I court with a plenary military dictatorship jurisdiction in Article I, Section 8, Clause 17 of the Constitution for the United States of America is defined as reinstated in the National Insurance Company of District of Columbia versus Tidewater Transfer, which further states that citizens of the District of Columbia are not embraced by the judicial power under Article 3 of the Constitution of the United States of America, which is essentially what Downs versus Bidwell said. And the same statement is held in Hepburn versus Dundas. In 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of D.C. was not a citizen of a state. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that D.C., District of Columbia, is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal court by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's taken from National Mutual Company of District of Columbia versus Tidewater Transfer Company, Supreme Court, 1948. This is where it's codified, boys and girls. This is under Title 26, United States Code. Used to be 770139. I think it's now 7408 C. Anyways, it says that if any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provisions of the title to A, jurisdiction of the courts, and B, enforcement of summonses. This is Title 5, United States Code, Section 552A. And this is subparagraph 2. The term individual means a citizen of the United States or alien lawfully admitted for permanent residence. And paragraph 13, the term federal personnel means officers and employees of the government of the United States, member of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. About that, boys and girls. What that means is that anybody with a Social Security number is federal personnel, okay, and is a government employee, okay, and if you think about it, that's why do you think they always want a Social Security number? They want you to give evidence, and then they can fabricate that you're a U.S. citizen. Then they can justify their assault, imprisonment, their military dictatorship. That's exactly what's going on, boys and girls. The term citizen in the United States is analogous to the term subject in the common law. This really is common law that's doing this. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by reason of their dwelling in it. They are subject to its laws. So long as they remain there and being protected by it, they must defend it, although they do not enjoy all the rights of citizens. They have only certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They're a sort of citizen of a less privileged character. They're subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. And this is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. Every taxpayer is assessed a trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. A citizen of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive Cesticate Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And that's congressional record. This is the DC Code, which was passed in 1801. I should say 1901. And so it says that in addition to the jurisdiction conferred on the preceding section, plenary jurisdiction, that's military dictatorship, boys and girls, is hereby given to the said court holding the said special term to hear and determine all questions relative to the execution of any and all wills. And then it goes on, it says the legal estate to be an assessed decay use, which is a use is what you see now called a trust. And then at the very beginning it says, and be it further enacted that in the interpretation and construction of said code, the following rules shall apply, namely, third, the word person shall apply to partnerships and corporations, unless such construction would be unreasonable, and the reference to any officer shall include any person authorized by law to perform the duties of his office. Okay, so again, any officer of the government is considered is treated as a corporation. Okay, partnership or corporation. Fourth, the word executor is used. It shall include administrator and vice versa, unless such application of the term would be unreasonable. And so, again, you know, there's people that go in and into these tribunals, these traffic court, so-called courts, and say that something like, if we can agree that I'm the executor in this matter, then we can proceed. And basically by doing that, the case gets thrown out. They stick to their guns. Anyways, the point is why do you think they started calling it an Bush administration or the Clinton administration or the Obama administration? Okay, this is all coming from DC Code and from that Downs versus Bidwell. I think it's Downs versus Bidwell. This is all done at about the same time. A U.S. citizen's a government employee. It's a Cesticate trust, and it's anyone who's not white. And I want to talk a little bit about racism. In my opinion, racism is satanic. Okay, it's the satanic doctrine of divide and conquer. They're enslaving everybody based on this racist doctrine. And I don't care whether you're what color you are, even the whites. Okay, I happen to be a white guy. Okay, and everybody, they're enslaving everybody based on this, and it's based on the. Why do you think they have their policies about racial profiling? Remember the racial profiling we talked about a little while ago? They better not be doing racial profiling. That's telling you that they want to enslave everybody. Okay, they're equal opportunity enslavers. If you're white and you think you're going to get treated better, you better think again. We need to put this behind us. We need to start treating everybody the way common law is really what we need to do, because common law, they don't care about your race or your status or anything. That means nothing. Anyways, we'll talk about some racist court citations now. The 13th, 14th, and 15th Amendments were mainly designed mainly for the protection of the newly emancipated Negroes. The 14th Amendment referred to slavery. Consequently, the only persons embraced by its provisions for which Congress was authorized to legislate in the manner of those within slavery. No white person born within the limits of the United States and subject to their jurisdiction or born without those limits and subsequently naturalized under their laws owes the status of citizenship to the recent amendments of the Federal Constitution. And, you know, you think this is still going on today? It absolutely is, okay? This is taken from Title 42, United States Code, Section 1982. Look it up, boys and girls. And if they didn't do this, people who are not white would have no rights under the rulings of these Baal priests, okay? You think about it. I mean, you know, the Constitution, I really believe that the people that wrote the Constitution, there was a lot of people that were doing everything they could to put in as many protections as they could. I think Jefferson was one of them and was one of the good guys. I think that you know, there's different schools of thought on Washington, but I think that he was trying to do the best. But there was some of them that were like Hamilton that were trying to that wanted a monarchy, and so. the point I'm trying to make is that there was Masonic influences. I mean, they're all over the place. Look at the dollar bill. It's all of these Masonic influences all over the place, and they've been there from the beginning. And if you read Albert Pike's book, Morals and Dogma, okay, he's an admitted Luciferian, okay. All of the Masons are really there. They may not know it, and many of them probably don't know it, but they're associated. The Masons are Luciferian. They're Satanists, and so many of these courts, okay, they wind up promoting these Masons to the courts, and so then you see these kinds of decisions coming out, okay. And in my opinion, okay, this is my opinion, there's a lot of Masonic influence in the courts. There's no doubt about it. You go into a lot of courts, and there's Masonic symbols all over the place. Anyways, this is Title 42, United States Code, Section 1982. All citizens of the United States shall have the same right in every state and territory as enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. Okay? And then the only absolute and unqualified right of a U.S. citizen is to residence within the territorial boundaries of the United States. And this is another quote from Diet versus Turner. In other words, when state martial law is imposed within the state to impose national martial law, Congress has no reason to exercise its martial law powers. If the state has conformed to the new order, there's no need for Congress to intervene. And if a white citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, i.e. statutory character of person, then Congress has no power over that individual under this clause. Okay, well, think about it, boys and girls. This is a judge of the Utah Supreme Court that's going through and explaining this. He's got about a 100-page document. It's actually quite easy to read, though, because it's double-spaced and it goes pretty quick. But this is what's going on, boys and girls. Okay, these are Satanists. This is all satanic. It's evil. It's all voluntary. Okay, Satan wants to get you into one of his so-called contracts. It's impossible to prove jurisdiction exists except a substantial nexus, absent a substantial nexus with the state, such as a voluntary subscription to license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Statutes have been passed. This is not something that's happened just today, okay? This has been happening right from the beginning, okay? This is the reason. This is the kind of stuff that caused the War of Independence. Okay, that's exactly what caused the War of Independence. This is taken from the causes and necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the custom and inestimable proof of trial by jury in cases affecting both life and property, to supersede the courts of common law and instead thereof publish an order and use and exercise of the law of martial. Okay, so they're imposing martial law on the colonists, and that's why they rose up in rebellion. Okay, matter of fact, when I filed my first case to the Supreme Court, I told them that the War of Independence didn't happen, and I don't believe it has. It's changed into a different format. Okay, and it's still going on today, and yeah, that's what I believe. Anyways. This is taken from the Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, and for imposing taxes on us without our consent, for depriving us in many cases of the benefit of trial by jury. Whereas taxation, and it's interesting to note, okay, that after the War of Independence, or when they signed a treaty of peace that Crown ignored, the first thing they did is 2 years. It only took them 2 years when we Declaration of Independence, and they went and passed this taxation. This George III, that pig over in England, Chapter 12, 1778. Okay, and do you think that's any different today? The bitch? No, it's not. Whereas taxation by the Parliament of Great Britain for the purpose of raising a revenue in His Majesty's colonies, provinces, plantations in North America has been found by experience to occasion great uneasiness and disorders. Well, no joke, Batman. The from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, or assessment, whatever, payable on any of the colonies, provinces, or plantations in North America or the West Indies, except only as such duties that may be expedient to impose for the regulation of commerce. And you know, it's interesting to note that Patrick Henry coined the phrase "live free or die" because he witnessed a guy being flogged to death for refusing to take a license. So they flogged him to death because he didn't want to get into one of their satanic contracts. It's exactly, this is what these kinds of people are, okay? You don't think it's going on today? Look at Irwin Schiff. Just died in prison at 85, chained to a bed. And, you know, it don't get me going about this stuff. It's still going on today. Martial law rule brings in Roman civil law and displaces the law of the land, which is common law. And see my martial laws here video. Martial law is brought in by the bankruptcy. See the bankrupt corporate so-called governments video. And the banksters video 1, 2, and 3. And the de facto courts video and the unidroit video. It's all coming from the UN. Okay, the United Nations is the source of all of this. Okay, and watch the unidroit video. Okay, under Roman civil law, status is everything. Actually, the real source behind the UN, Vatican. Under Roman civil law, status is everything. Okay, under common law, status is nothing. That's why they want to supersede common law and replace it with their martial law, their Roman civil law, because then they can just move ahead with all the rest of the stuff. Okay, status is everything under Roman civil law. Under common law, status is nothing. And again, give me liberty or give me death. That's Patrick Henry after he witnessed a man flogged to death for refusing to take a license. So what can we do? Well, we can do a lot of things. We can lay a proper foundation so they cannot claim ignorance. Plausible deniability is their biggest defense, okay? Oh, I had no idea. And you take away that plausible deniability and everything changes. Demand common law court. Know what a true common law court is so you can tell if they really give you a common law court. Complain to the Judicial Council, which is really a council of whores. Make sure you bring up the right issues. They'll probably blow you off, but I guarantee you that it has an effect. I guarantee you. Complain to the politicians, okay? Now, you know politics is a compound word. Yeah, poly, meaning many, and ticks, meaning blood-sucking insect. We need to work together to fire these Vatican Jesuit clerks masquerading as judges selling their justice. And, you know, this is appropriate, okay? Never, ever, ever give up, okay? It is never over till it's over, till you say it's over, okay? And so never, ever, ever give up. Make YouTube videos, circulate them around, send YouTube videos to me, I'll circulate them. Realize it is never over until you say it's over. Never, ever, ever give up. There's a judgment day coming, and they're all going to be held accountable. Always remember that we, the people, are the ones who are really in control, not a gang of Vatican judicial whores selling their justice, not their hired code enforcers, you know, and there's Leos, there's satanic order takers. Watch Mark Pacio's videos about that law. They're not the Canada border pigs, which is a good example of satanic order takers. They're not the U.S. border pigs, which is another good example of satanic order takers. Actually, they're all Canada or U.S. They're all United Nations border pigs. Even a peace officer can do nothing that we ourselves cannot do. We can refuse to participate in their de facto system. We can educate ourselves about what a common law jury is and what the law of the land is. We can educate ourselves so we know when our rights are being violated. We can educate our public servants because many of them don't know any more than we did. Okay, again, we got to take away their plausible deniability. This is all the bar members. Okay, they keep these code enforcers pretty well in the dark, and so many of them do not know. Okay, some of them do. There's whole organizations called Oath Keepers. Okay, they actually come out and say that if they tell us to take guns, we're not doing it. Okay, but they're trying to weed those people out. And so we need to support the Oath Keepers, okay? I would say absolutely support the Oath Keepers. We need to support them. You know, the Soviet Union, when the Soviet Union collapsed, it was because the Oath Keepers refused to follow orders, okay? And then it collapsed, okay? That's what has to happen, okay? Is that the Oath Keepers there needs to be more Oath Keepers, more peace officers than MEOs, and to the point that they refuse to follow orders, and then it'll all collapse. We can educate other people by circulating this video in many other ways possible. We can demand a common law jury of our peers. We can work with our friends and neighbors to reestablish our common law jury of our peers and our common law de jure courts. We can work with our friends and neighbors to get the UN out of America and Canada and anywhere that wants to be free. The UN is owned and operated by the bankster thieves and their Vatican handlers. Recently, I saw a picture of that Pope Francis, or the pimp. No, not the Pope. No, maybe he's a pimp. I don't know. One of the two. Anyways, that Francis kissing the hand of David Rockefeller and I can't remember his name, but he used to be Secretary of State, I think, under Nixon. He's a big New World German guy. Anyways, so the point is that it's the bankster thieves and their Vatican handlers. Other videos to watch: Bankster Thieves 1, 2, and 3, Churchianity series, bankrupt corporate so-called governments, bar members. That's a good one to watch. Unidroit, we're under martial law rule, quasi-contracts and Roman civil law, de facto courts. All courts are ecclesiastical courts, DC courts in Texas and jurisdiction. Copies of these documents can be found in my private group at Yahoo called Administrating-Your-Public-Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for donation. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept IOUs, Federal Reserve notes, PayPal gifts, checks, money orders. Send me an email for particulars. Send me an email for other copies of documents to engineerwin@gmail.com. I appreciate you taking the time to watch my video. I hope you got something out of it, and spread the word. Okay? There's strength in numbers, and we got to put a stop to this, and it's all going to get put a stop to eventually. I guess the end result is how which side are we on? You know, that's really what it comes down to. Anyways, appreciate you watching it. I hope you got something out of it, and I hope it motivates you to some action. Have a great day.